that particular statute, which is 451117, says that Mr. Greenlee did knowingly without lawful authority move, deface, damage, destroy, or otherwise improperly tamper with a traffic control device or a sign or signal. I think the interesting question, Mr. Kingsley, I think addresses an interesting concept here, which is clearly present in the law, and that is the mere presence issue. It's a very interesting fact pattern. I guess my concern is, and I guess from the state's perspective, Mr. Kenworthy, I mean, what evidence is there that actually says that Mr. Greenlee did participate in moving, defacing, damaging, destroying, or otherwise improperly tampering, other than being in that car? I mean, yeah, what do we have there? I guess. What is the connection there in terms of him actually committing a misdemeanor?
Well, he's operating the vehicle at the time of the participation. He drove it from the scene with him later that evening. With him prior to that time, we don't know at this point exactly what kind of conversation might have been taking place between the two of them when they went up to the stop sign, other than the statement that the girls indicated they made afterwards. I think there's clearly a participation on his part that evening with the primary offender.
I guess not everybody who drives somebody to the bank involved in robbery actually commits the robbery or is a participant in the robbery, I guess is the issue. I mean, there has to be some evidence connected to the robbery.
If I drive you to the bank, Your Honor, I don't know you're going to rob the bank. I'm not an aider and abettor. You come out with that gun and the stuff, and I say, oops, I'm not guilty. And we understand this case. This is a hard case politically. It's a hard case because this case got hyped up and charged before the facts were brought forth and got a legal reasoning on this. I'm sure if the sheriff had gone to Mr. Kenworthy and asked for a legal brief on these facts, and he would have cited the Supreme Court of Iowa law, he would have said, don't charge it. But now we're stuck with the press and the sheriff, and they put their foot in a tar baby, and they can't get a good foot out of it. They jumped the gun.
I'm going to take this under advisement and look at the facts and circumstances and the testimony and the case law, and I will render an opinion. I have to take it under advisement. Until that time, we'll modify the bond from a $25,000 to a $25,000 10%. Clerk's office will be given the authority to refund the balance of the bond less than 25%, which will still be a $25,000 bond, but it will be a $25,000 10% bond. And I will take it under advisement and will issue a written opinion. I need to think about it further. Thank you very much.
Thank you.